going to talk about, surprisingly enough, estate planning and how it will help you to be more comfortable and happy in your twilight years. So we're first going to hear from Christine about some specifics that young couples can consider and can do to get their estate plan in order.
Absolutely. And I'm happy to talk about this because I think there's a bit of a misconception that estate planning is only needed for the wealthy or not until, your later years in life. So there's sort of two events that I look at that occur earlier in life often that sort of trigger the need for an estate plan. It's often the purchase of your first home and having children. So a basic estate plan, you're typically putting a will in place, a trust in place, a healthcare directive, a power of attorney. These are documents that allow you to name individuals to act on your behalf in the event of incapacity, documents that allow a person to make healthcare decisions for you when you're unable to make your own, documents that allow you to name guardians for your minor children. Very important. So even if you haven't accumulated a significant amount of wealth yet, you need an estate plan. You need someone to make decisions for you in the event of incapacity, and you need someone to care for your minor children. As far as I use the example of purchasing a home as the need for an estate plan, because there are many different types of trusts. Sort of your basic revocable living trust is one that most of us here in San Diego probably need, because when you own real property in excess of $50,000 fair market value, which is everything in San Diego, unless maybe you have a small piece of vacant property somewhere, but just about everything. Unless there's a surviving joint owner on that parcel at the time of your death, it goes into probate. So if a couple purchases a home jointly, after both of them have passed away, it will then go through a probate process. So you put that in a trust. A trust does many things, but that trust in this context allows you to avoid probate. It passes to those children if the young couple has children, in accordance with the instructions you put in place in that document. So it's a good way to leave your instructions in place and keep your family, your assets out of court and avoiding that expense.
Makes sense. We're talking with Christine Chacon. Her website is walshlawapc.com. walshlawapc.com. So I want to go back one more time because there's still people out there that hear what you're saying and are not rushing out to get an estate plan in place. So let's go one more time. There are certainly instances when it makes sense to have one even if you don't own a home or have children, but certainly if either of those two events happen, there is a huge benefit to having an estate plan, right?
Certainly.
And you mentioned many of them. One big one is probate avoidance.
Correct.
Right? Probate avoidance. And the documents we're really talking about are, go through one more time.
Wills.
Wills, yep.
Trusts, advanced healthcare directives, and power of attorneys. And in a more general perspective, not just for that young couple example that I'm giving or purchasing the first home, we were talking about the value of a property, real property in excess of $50,000. If you own that at the time of death, it will go through probate unless held in trust. You might not own a home. The rest of your assets, your cash accounts, investments, if there is no beneficiary on that account that you own or those accounts, if they exceed $150,000 cumulatively at the time of death, those will also go into a probate process. So by titling these assets into a trust and putting a trust in place, you can avoid this whole court probate process.
Sounds like the right thing to do.
It is.
For many reasons. And we'll still find there's people out there that don't do it, right?
Correct.
But it still seems like the right thing to do. Okay, let's assume we've convinced them to have a trust. Go through trust administration for the benefit of minors. Okay. How does that work?
Certainly. So when you're putting together your trust, you're putting in place instructions for your trustee to follow. Those instructions will say who your beneficiaries are and what they'll receive from you. So it might say, John Smith and Susie Smith each receive 50% of my estate.
Right.
If those are the children, there's usually instructions in place, if those children were minors when the parents created this trust, there's usually instructions in place as to how the children will receive those assets. In other words, if they are not 18 or over, there hopefully are instructions in that trust stating how the trustee should manage, maintain, and distribute the assets to the kids. So during the planning process, part of the conversation is, what are your goals for your children? How, you know, depending on their age, how responsible are they? When would you have felt responsible with a large amount of money, perhaps? Even if it's a small amount of money, this needs to be considered. So what you could state is, my children can receive a portion of their inheritance upon completion of college.
Okay.
Or you might stage it out.
Maybe some for college.
Correct. Or you will hold it in trust and instruct the trustee to distribute tuition, college tuition and expenses, and then maintain the rest in trust until after college, and then they might get another distribution at that time.
Right.
Perhaps upon a certain age, then they can access more of it. So in the trust administration process, after somebody has died, we are working on getting those funds out in accordance with the instructions in place. A staged distribution would look like one that says Susie Smith can receive 25% at 25 years old, half of what remains at 30 years old, and the balance at 35. During that time period, you then have a trustee who's managing what's still held in trust. And there might be further instructions saying if she would like to pursue an advanced degree, or if she would like to put a down payment on a first home, or start a business, then the trustee can give her a principal distribution for that reason if the trustee, in the trustee's discretion, deems that appropriate. So that's just one example. It can really be set up however you intend to when you're putting this in place. So if you're sort of thinking of what are your goals for your beneficiaries in the future, you're getting that down in writing, so your successor trustee, the person who will carry this out for you as your fiduciary, knows what to do.
Yes, they don't have to guess at what you wanted.
Correct.
Right? I really see that as the big upside, putting it in writing so they don't have to guess as to what you wanted. We're talking with Christine Chacon. She's an estate planning attorney as well as a transactional attorney with Walsh Law. The website is walshlawapc.com. walshlawapc.com. So what about the nomination of guardians? Is that an issue that needs to be addressed? And what is a guardian, first of all?
Certainly. The guardian is the guardian of the person, the caretaker of a minor child. Okay. When you need to, if you have minor children, you need to nominate a guardian, and you do this in your will. And in the will, you're stating who takes care of those children if they are under age 18 after you and their other parent are deceased. And that guardian, they still have to be appointed by the court. So there's a lot of considerations to make sure you're appointing the correct person in your document. Is the guardian someone who is willing and able to serve as guardian?
Yeah.
Certainly we encourage our clients to have the conversation with the guardian before actually writing that person into their will. Do they have a home suitable to take the children in? Or is it your desire for the children to stay in your home and the guardian to reside there? If that's the case, we have to put some specific provisions in both the will and trust to make sure that those wishes are written down and align, and that there's that home to provide for the children and the guardian. The guardian is the person who will think of day-to-day life, the person who will be taking the children to the doctor, the person who will be signing the paperwork with the school. You know, very personal decisions. Exactly. They're becoming the parents. So it's a very personal, important role to think about. You might consider religious values, whether or not they have children themselves. Will your children do well residing with their children? And you really just have to think of how your children would fit into their home, their values, their lifestyle. Are they home and able to get the kids to school, or are they in a career that requires a lot of traveling, so they might not be around to actually help with the day-to-day life often. So a lot of factors to consider, but such an important thing to consider, because what you don't want to happen is to not name a guardian, not have a will in place, and then have, you know, families in court battling over who will end up being the guardian, and dragging these poor children through it, who've obviously just been through something tragic, losing their kids or losing their parents. You know, if you have this thought through in advance, it helps the children and it helps the rest of your family. And it's a difficult decision. I just had a baby myself, which I know I told you recently, and you know, my husband and I have been talking about it, and it's, who do you name? It really takes a lot of thought, and I really encourage my clients to think of it and not just name the first person who comes to mind. Think about it and talk to that guardian, and it goes hand in hand with who's your trustee also. The guardian is not, by being appointed guardian, they can't reach into your bank accounts directly. It doesn't mean that they're the one managing the assets. So you may have a different individual named as trustee, or it could be the same person. It depends on your circumstances. So if they're different people, you want to be sure the person managing the finances, the trustee, and the guardian can communicate with each other.
Yeah, that sounds crucial.
Absolutely. And if they're the same person, you want to make sure they can take on all of that.
Makes sense. We're talking with Christine Chacon. She is an estate planning and transactional attorney with the Walsh firm, Walsh Law APC. The website is walshlawapc.com. That's the website, walshlawapc.com.